Thank
Perfect.
you so much. It's a great opportunity to be here. So, my intent today is to cover a few slides in the first 30 minutes to give you a overview of what are the different career streams that are available for an IP professional in an in-house role, in a corporate role. Of course, in a law firm, things might be slightly different, but typically, what I will cover is, what happens as an in-house role. Uh, I'll also, try to tell you that for each of those roles, what are some of the skill sets required, some of the challenges that you may face, etc. And then, the next 30 minutes could be devoted for answering any queries that you may have. So please, keep your questions ready. I'll try to answer whatever I can. And otherwise, if I don't have any answer, I'll surely get back to you. But let us try to make it as interactive as possible. Okay, now, if you really look at the first question that often comes to our mind is what is expected from an IP professional in a corporate setup, and what are some of the goals. Now, if you really look at the goals of any IP professional or any company when they want to drive IP strategy, there are three broad buckets as the way I would classify. Of course, these are not standardized. I mean, people can classify it in different way, but the way I would like to classify is the first bucket, which talks about how do I generate IP and protect those IP, identify all the proprietary assets, ensure that first is the identification stage. So you need to have a process around identifying what are the ideas, innovations, or product ideas or service ideas, whatever that comes from the organization. As an IP professional, you are expected to identify and have a process of identification. Once you have identified those IPs, those assets, the next stage would be how do I best protect it. Now, protection strategy has to be built in, protection processes have to be built in, where we generally talk about whether a patent is the right approach, or should we go for a trademark, keep it as a trade secret, get and go and get a copyright, or a combinations of any of those. So there has to be a strategy behind it, and the underlying downstream processes. What I mean by underlying downstream processes would be, uh, if you are trying to file a patent, how will you file a patent? Who is going to draft the patent? What are some of the search that you would do? Whether you call it patentability, novelty, prior art search, different searches are there. You will have to do those searches to figure out what is the novelty, and then have the downstream process of drafting the patent application, making the inventors file a disclosure document, which would be your starting point to understand the invention, then go for drafting, and then filing, and then the prosecution until the grant is obtained. That is what I call as the downstream processes. And then you of course have, how do I mitigate some of the risk that may be involved. Risk could be of different nature. It could be a litigation risk, it could be an enforcement risk, it could be any kind of a compliance issues that may be required. Now, with the advent of AI coming in, there are of course lot of inherent risks that are associated with IP. Some questions are not very clear for the IP professionals, and it will evolve over time. So those all aspects need to be managed through the risk mitigation sub bucket under the main bucket. So IP generation, protection, risk mitigation, all of it comes under that first bucket. Now, the first bucket also involves what are the processes that I have in terms of, let's say, incentivizing the inventors. Now, obviously, as a role of an IP department is not just about protection, but to ensure that the inventors are recognized for their invention. So how do you manage the inventor recognition program, the patent reward program, whatever may be there, right? I mean, at the end of the day, it is an obligation and a duty from our end to ensure that we keep the innovators motivated. So all that comes under that bucket. There could be also strategies of building an IP portfolio. You have to keep in mind that while you can identify assets, you can evaluate those assets and see what best protection you can have. But there is also a inorganic way of trying to grow your portfolio through acquisition. Acquisition could not is not does not necessarily mean that you will have to acquire the company for getting the IPs. You can also target IP acquisition, or a small chunk of strategic patents that you feel are important for the company, and you acquire those patents and then build your portfolio in an inorganic manner. Now that also involves a lot of what do you say processes, because it is not just about acquiring the assets, but you have to there is a process involved of how do I do the due diligence, how do I really figure out the quality of those patents, what do I do with those patents, what will be my cost involved in maintaining those patents. All of these needs to be uh, you know evaluated before you basically decide that yes, I'll acquire the portfolio. Again, acquiring the portfolio is not the end of the story. You have to not only maintain the portfolio, but you have to integrate the portfolio. Sometimes you may have to change your assignee. You will have to see whether I can file further patents around those inventions. Or you may decide that no, certain portfolio or certain patents out of that portfolio I'll not maintain. So all of these are activities that you will need to do, and for which you again need to develop those policies, processes, competencies internally. So overall, I think these are at a very high level the activities that are involved under the first bucket of generation, protection, and risk mitigation. Then comes the second broad area, which I say that how do I manage IP in my contracting process? Because you have to understand that end of the day, whatever you are protecting from the first bucket needs to be commercialized. You have to make money. Now, how do I, uh, you know, ensure that the contracts that I sign with my customer, or the potential parties, are well protected, and how do I ensure that my risks are mitigated contractually? So all of these comes under the second bucket, where in a commercial transaction, you would realize, and you will see people who are in the software area, they'll know that it is not just your proprietary IP that gets commercialized in a real world, but you have a lot of third party tools that gets integrated into the product or services. There are a lot of open source, free and open source softwares that are used, freewares are used. So therefore you need to understand the risk involved, the IP ownership of all those third party components, how those are getting embedded into the overall product. How do you classify or demarcate your risk versus a third party risk? Those needs to be covered contractually, and that's where the IP professionals need to play a larger role. Now, one thing which I will also mention, the IP protection or the generation part, is not, I gave a lot of examples around patent, but the same holds true for even other IPs, which is trademarks or copyrights. They have their own processes, they have their own evaluation that you need to do. If you have to file a trademark, you have to do certain knockout searches on the mark before you can conclude. So you will have to do all those exercises. Same is the case with copyright filing has different procedures in different regions, so you'll need to know those procedures and follow those procedures. Coming back to the third bucket, which is around how do I make money, which is monetization, exploitation. The second bucket and third bucket, there may be an overlap, but the second bucket primarily talks about the contracting piece, whereas in the IP monetization, how do I actually make money? Now when you say making money out of IP in a internal in-house setup, it is not necessarily that I have to generate license revenue from my uh, product always from my patent. That yes, I have to license out my patent, and if I get some money from the customer, then I can consider that those are IP revenue. Yes, it is straightforward IP revenue, IP licensing revenue or patent licensing revenue, but there are other ways of also monetizing. It could be indirect monetization. For example, you could use your patent to block certain competition. Now thereby you can end up charging a premium on your product. So therefore that's also a kind of a monetization. You can use your portfolio as a branding advantage or a differentiator. So there are different ways of indirect monetization and exploitation which you can do. That's why I use the word exploitation. It need not be always that you there's a money associated, a direct money, but it's a form of an exploitation that you do. And then you can get some tax benefit in certain areas which allows tax benefits on IPs. So those are aspects that you can do. You can actually do a valuation of your IP asset, have it incorporated in your tangible assets of your books. So those are different ways of doing it. And of last but not the least is, of course, how do you enforce your IP? You In terms of what I mean by enforcement is that, yes, if you see a potential infringer of your IP, can I enforce my IP rights? Can I assert my patent rights and get some money, a licensing revenue, or do a settlement, or whatever may be the or even get into a litigation dispute, etc. So these are aspects that broadly covers the third area, the third bucket. Now, for all of these areas or some of the buckets, you will also have issues around dispute management, whether it is, any kind of. While in the third bucket, I gave you the example of how do you assert your patent rights or IP rights against a third party. There could be the reverse scenario where a third party may actually assert their patent rights against you. How do you defend that? So those are some areas where IP professionals definitely need to play a very important role, and you should have that skill set. So this is what is overall expected from the IP professional. Let me take you to the next one, where it's a detailed slide which talks about the different activities. I've talked about broadly many of the areas that I spoke on the first slide. You will see it again in the second slide, but this basically tells you the activities. For example, in patents, you of course have prior art searches, you have novelty assessment, drafting, prosecution, filing, or any kind of a analysis that you do, whether you want to do a patent landscape analysis and competitive analysis. You want to see what my competition is filing, where are they filing, what are they actually filing. You want to figure out that, yes, there's a new area that has developed. Can I see what are the areas where people may not be filing, which could be a good opportunity for me to block that space? What are some of the areas which is already blocked, and I possibly will should be very careful if I have to enter that area? So those are the landscape analysis that you do. You can also do analysis to figure out who are the potential infringers so that you can enforce your patent rights. Then you have to maintain your portfolio, right? I mean, overall, in course of time, you will have your patent portfolio would have grown. Now, if you just sit on the portfolio without doing an audit of the portfolio, without maintaining the portfolio, or abandoning the ones that you don't use, you will end up with very high cost, which is also not going to be feasible in long run. So you will have to constantly do those audits to keep the portfolio live and more active and meaningful. Same is the case with copyrights and trademarks. You have those searches, you will have to do the filing, you have to do dispute management, you have to send out notices or respond to notices. All those activities come under copyrights and trademarks. And then in terms of managing portfolio, as I told you, portfolio analysis, doing the asset management, maintaining your portfolio, maintaining the cost, because some of these activities, remember, not everything may be done in house. You may also outsource certain work to different law firms. Now, when you do those, you will have to review those work, ensure that the work aligns to your overall strategy, because a law firm may not know the IP strategy of the company. That is for you to drive. But the activity that they do should be aligned to the strategy, and therefore the in-house professional's role is to see whether that alignment is matching, and whether they are filing as per whatever is your long term goal. So you will also have to work with the law firms to do maintenance, but at the same time do some cost optimization to see that you're not overshooting the cost, because everything is you'll have a budget for everything. So all of it, when you are doing the portfolio analysis, all of these activities come into play. There could be also in the contracting space, you can also expect work around joint collaboration, whether you are doing some collaboration or partnership with universities, academia, or even companies, different vendor partners, etc. How do you protect your IP? How do you own the new IP? Who owns what portion of the IP? How do I protect my existing IP? What kind of licenses will I give to the other party for generating a new IP, but I will ensure that I give that IP as a license and not allow the other party to own. All of it comes under the joint collaboration activities. Then audits, we talked about. Trade secret is another area which is important, especially with the speed at which some of the technologies are moving. There could be a strategy for some companies that they would want to keep certain ideas within themselves rather than filing for a patent or disclosing it too much externally. So therefore you need to have a very strong trade secret process inside the company to ensure that those ideas or confidential information remains within the company. And if there is a leakage, then you will have to get involved to see how you can mitigate those leakage. How do you ensure that your employees are protecting the proprietary information that they are privy to? And last but not the least, the IP processes, which is extremely important, because while the other ones that I talked about are the activities, but IP processes are the boundary conditions, because it defines different policies, it defines different processes, guidelines, templates, and these needs to be updated, these needs to be changed from time to time. So if unless you have the process, the governance and the control, you will never be able to drive IP management, irrespective of whether you have the best strategy or not. So a lot of emphasis needs to go into the IP processes piece, where IP professionals need to play a very, very important role. Training is another area which is again a continuous activity that needs to be done within the organization. You have to train your technical people, your business teams, your other teams, and keep them updated on the processes, what they should do, what they should avoid. All of these goes into different trainings. Also, training the IP professionals within the IP team is also important, because technology is changing, the laws are changing. So you need to keep yourself updated with the latest information to drive IP strategy. So internal training also plays a very, very important role. And also to overall have the culture of IP within the company is also very important, because IP management is not just about always a process or a governance or an activity. It's an habit, it's a mindset. So therefore those things have to be also covered in the overall IP training. Awards, communication, docketing, of course it is part of the administration. Budgeting, all the employment matters becomes important, because there may be some breaches on IP, or there could be issues where you may be hiring somebody from external other company, and then there may be some IP conflict that may arise. There could be issues around non-compete, etc. So the sharing of confidential information. So those all needs to be covered by the IP team. So these are just a snapshot of some of the activities that are expected from the IP professional in different headers, and there could be more than this. The way I look at skill set, apart from obviously knowing about the subject matter, the law, the process, and etc., that is given. I mean, you cannot compromise on that. That's absolutely inevitable. What is important is, apart from this, I think the habit of upskilling yourself, or motivating yourself to upskill and learn is extremely important, irrespective of whatever may be your age or experience or qualification. Upskill has to be done, otherwise for any profession. Otherwise, anybody can become redundant at any point in time. The habit of upscaling, which involves reading, writing, networking, is absolutely important for IP professional. If you don't, if you miss out on these things, then you will find that you're lost somewhere, and it becomes extremely difficult to bring yourself back if you don't get into this habit. Second important and critical skill set is forward looking, being proactive and analytical. This is one of the very important aspect which is required for any IP professional. You need to think beyond your present time. You need to, when inventors are coming with an idea and they are seeking your advice on how to best protect it, you have to think not for today but tomorrow how the technology can be used. What are some of the other use cases which even the inventors may not be thinking? Because that will help you to give the right advice in terms of what best protection strategy you can adopt. So you will need to have that analytical mindset, be very proactive. The third aspect is business alignment and challenging the status quo. What I mean by is that if you have set up everything, your house in order, you may be thinking that this is the best I have done. This is the industry best practice, and I'm doing what other companies are doing. And but then if you don't challenge your status quo in periodically, then eventually you will see that you have not really benchmark yourself. So you will always have to go with the assumption that there could be something that I can do better. So challenge the status quo, and ensure that you don't run your IP processes as a standalone process. It has to be aligned to what business wants, what business needs, and what is the final outcome that the company wants. If you are running a practice which is just like expecting that, okay, it's like a shop that I'm running in a locality where I will just be standing and sitting and let people come and ask me, then only I'll come. It doesn't work in an in-house environment in IP. You have to constantly be in touch with business, understand what they're doing, guide them, take their advice, help them, and then they will somehow feel that yes, this guy is going to give me some value add. He's able to add some value to my overall goal, and that will essentially help you build a partnership. That's how you can drive IP strategy. And last but not the least is have a passion for technology, especially if you are in the field of patents. Because if you don't love technology, then you may get bored very soon on doing patent work. So you should understand. It's not that you need to be expert in any technology, but at the same time, you need to educate yourself with the basic information. Today's world is so easy to get yourself educated free of cost. So many courses are there. You need to do those basic courses, get yourself equipped, and again it is linked with how you upskill. And then of course business and law are the basic primary skill set that is required. The last one, this is my last slide, and then I'll open up for questions. Overall, I think the way the approach should be that you will need to rethink on your IP strategy always. It cannot be a constant, it cannot be a static IP strategy. It has to be focused on what the business wants, what the company wants, and it should be measurable. You cannot have a goal which cannot be measured. It has to be measured. If you're talking about saying that I'll file all the filings that comes to me, that that is just a activity. But can you put a metric saying that I will ensure that 50% of whatever I file should have some kind of a commercialization value or monetization value? Then it becomes a measurable goal, then it becomes a outcome based goal, more strategic in nature. So that is one aspect. And if you do that, then your efficiency overall increases. It reduces your overall cost. It contributes, you are able to contribute to the revenue generation and growth of the company, and then thereby business will see a value from that. So overall, I think the that I first aspect is changing your IP strategy constantly. The second part is execution plan. This has to be constantly changing, because this will affect the overall effectiveness of your IP program. how you can customize your IP models, how you can actually enable growth for the IP team members. Because you have to also remember that IP models or IP strategy or whatever IP you want to drive in a company cannot be one static, which I told, but more importantly, it is not a one size fit all model that yes, just because company A is doing this, I'll do this. That that activity may not be even relevant or meaningful for you. So you will have to devise your own models by looking at and reading all the models, understanding some of the industry best practices. But end of the day, you will have to drive those for you, whatever works better and how it works. So those aspects are important. Now, the last piece which I also wanted to cover was in terms of competency. Now, in a in-house scenario, you will find some people in the IP professionals who may not be lawyers, who may be having technical knowledge, technical qualification, and may be interested and passionate about IP, and they may have experience and they may want to pursue the career. Then the second part is people with pure law degree or lawyers may also choose for IP as a profession. And the third could be a combination of both. You can have uh, mm, uh, technical people with law degree or a combination of both in some form or shape. Now, depending on what your skill set is, if you are coming from a background where you feel that you may not be able to add much value in the patent world because it requires some technical knowledge and you're not able to build that, then you can look for other areas. And I talked about areas which you can contribute. You can contribute on trademarks, copyright, developing IP strategy and processes, doing certain activities relating to monetization or contracts, like in terms of licensing. How do I contractually mitigate my risk? So all these activities you can do. People who are you know who has a inclination or a more inclination towards technology may choose patents and all the activities around patents. So therefore there are work that are meant for different areas of people, and there is a career transition also that can be expected. So there are many companies who may have a a hybrid kind of an approach where they'll say that okay, one person will work on patents, copyright, trademarks, do a bit of audit, do a bit of processes. It can be all of the many things. There could be other scenario where they may have segregation in terms of whether you know what do I say, I mean, they might say that there's a team of patents. Now you work on patents for 2 years, then after you are done you can move to trademarks, or you can move to copyrights, you can move to audits. So there could be a career transition that happens from one stream to another, and by the end of x number of years you really become a generic IP professional having knowledge in everything. But whatever process you follow or what the company follows, end of the day the goal should be to acquire as much knowledge as you can in different areas of practice, and then see what best you can do, how you can upskill, how you can develop, move further to what you have already learned. So that is all I think I had to cover today in terms of slide. But then I'm open for any questions or anything that you feel I may not have covered. I'm happy to answer.
Great, sir. Thank you very much. Thank you. It was a really comprehensive and a top view, which usually, we don't see. It's because we are always talking about our fields. So I took a session on patent analytics yesterday, and I see that it was such a small part of the entire, umbrella of things that you have mentioned. So great. I'm sure the audience saw these kind of things for the first time. So, sir, I can ask you one or two questions before we
Sure.
get the audience. So, sir, how big is the team of IP in, say, Cognizant or in typical, industry-wise, like in IT sector in India? So, how many employees kind of are there?
See, it's a very difficult thing to put a number. I'll tell you why, Rahul. But the point is that what happens is that in certain companies, the definition of the IP team may be little broader, and in certain
Hmm.
companies, the definition of IP team may be just restricted to what I showed today, right in the slide.
Hmm.
Now, if you really look at the activities that I had shown you in the slide, which is pure IP, if I say core IP work, uh,
Hmm.
the team size may depend on 10 to 15 or 20 people. Okay. Now, there are companies which may expand to a little broader, saying that while these are activities, but I will also include activities relating to IP contracts into the IP team. So all the contracts with the universities or with a third party that I'm doing, or I'm licensing in a particular technology, I'm doing a technology transfer contracts, I will include in an IP team. Now, if that is included, then you will have more lawyer strength, and
Hmm.
the team may increase to 25, 30 also, right?
Hmm.
Now, so therefore, some companies may say that my open source compliance team, which also is part of my IP team, then the team size may even increase to 40 people also. So, but then
Hmm.
if you're looking at a core IP, it is usually between 10 to 15 or 20 people is
Hmm.
what I have generally known.
Great, sir. Great. Thank you. And sir, one more question before I get to the audience, sir. How is hierarchy? Like, suppose you have to report to which kind of top management, and because you said that IP people have to actually interact with all departments and take
Correct.
initiative and keep going to other people, not wait for people to come. So what are
Correct.
the hierarchy basically?
So typically, in majority of the company, the IP function is part of the legal function, the corporate legal function, and usually the head of the IP either reports into the general counsel or the group general counsel, so on and so forth. Now, there are also certain organizations where the IP function reports into the CTO organization, the Technology Office organization, where the head of IP may directly report to a CTO, or there are organizations where they have Chief Innovation Officer also, like
Hmm.
who is basically responsible for driving innovation, and a major portion of the IP department reports into that person.
Hmm.
But usually what I have seen is in an Indian context that it is part of the corporate legal team, and the IP head usually reports to the general counsel, is what I have seen.
Hmm. Great, great, great. So thank you. These things we are difficult for us to know and the audience.
Sure.
So, sir, one more maybe question. So you mentioned all different kinds of IP. So which one is the most important focus? Suppose copyright, trademark, trade secret, trade designs, patents. So out of these five, six different kinds of IP, where is the most important focus for companies?
See, you cannot really put a emphasis because it depends on the industry type. Okay,
Hmm.
because these are different forms of IP, and the nature of the